This is Rob Ryder on Saturday, August 28th, 2021. And today I want to talk about Esquires' conspiracy to defraud the United States and to inform Lieutenant Colonel Scheller to hold those learned in the law accountable. Now, the good colonel, right, if you haven't been paying attention, I can't believe you haven't, right, is the Marine officer who posted a video calling out senior leaders in Afghanistan. He was relieved of command. And as you know, the colonel knew that's what would happen to him if he did it, and he did it anyway. So thank you, sir. But the headline's a little bit misleading because actually what he said is to the American leadership. Well, right, that would be the civil authority. In other words, what the hell are you people up to? I'm here to tell you, sir, that they're not the civil authority. The people that we believe to be in power are impersonating officers of the United States. They did not take the proper oath. All right, here's a perfect example. Right, so in 1968, Biden earned a Juris Doctorate from Syracuse University College. He ranked 76 in the class 85, and he was admitted to the Delaware bar in 1969. So he's an Esquire. Well, there's that Esquire. And over here is another Esquire. And these two together at this particular moment, and what it should be, the public ceremony for the oath of office for the president, right? They're going to recite an improper oath of office, right? So now I have done a video on this, sir. Just so you know, right? If you were to go here to Rob Ryder, ROBBBRYDER on YouTube, I was telling General Berger, Court Martial Joe Biden, because he took the improper oath of office. Right? So there will be a lot more detail there. I'm not going to go into it all right now, but let's just look at what he was supposed to have done, right? Section 1 of Article 2 of the Constitution says that before he enter into the execution of the office, he shall take the following oath or affirmation. I do solemnly swear that I will faithfully and execute the office of President of the United States and to the best of my ability preserve, protect, and defend the Constitution of the United States. If you watch the video that I did, or you go find it for yourself, sir, you will see that while they were standing there, that this Esquire, Roberts, says I, and then he puts in whatever Biden's full legal name is, right? And then does the rest of the oath, and at the end, then he says, so help me God. Well, so help me God is a religious test. And there is no place in the oath where you can put the word I in, right? It's supposed to have done it just like this. I do solemnly swear. Not I, Joe Biden, do solemnly swear with so help me God at the end. So he didn't take the proper oath. Now, Trump didn't take the proper oath either, and neither did Obama, and neither did Bush or Clinton, or we just keep on going back. It's been this way for quite some time, right? But it doesn't change the fact that they didn't take the proper oath of office, so that, you know, Biden is not the frickin' president. But he is an Esquire, and so is Roberts. And these Esquires are conspiring against the United States, which has its own section of law, which is 18 U.S.C. 371, which we're going to get into in just a minute. But, you know, it's also covered under the UCMJ, sir. Where are UCMJ? Where did I put you? There you are. All right. Where if you were to find the UCMJ, right, Uniform Code of Military Justice, and put in the word conspiracy, you would see that it's been used 4 different times. So let's go see where it was used. Well, there's one conspiracy. Any person subject to this chapter who conspires with any other person to commit an offense under this chapter shall, if one or more of the conspirators does an act to affect the object of the conspiracy, be punished as a court-martial may direct. Well, Biden is supposed to be the commander-in-chief, so he's covered by the UCMJ. But as it turns out, so is Roberts, because he sits in a room that has a gold fringe flag. And then here, under Section 43, we're talking about statutes of limitation. When the United States is at war, which it is, the running of any statute of limitation applicable to any offense under this chapter involving fraud or attempted fraud against the United States or an agency thereof in any manner, whether by conspiracy or not, yada, 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 right, that has been suspended. So I'm saying there's a conspiracy because these two Esquires who are learned in the law, there's no reason for them not to know that the oath they're taking is incorrect. And whether they know it or not, it's not my concern. I'm saying, hey, you're learning the law, dude. You need to know what it is. I know what it is. You need to know what it is. And the I in this case, sir, is Staff Sergeant Robert Allen Rutluski, a.k.a. Rob Ryder. And my email address is courtofrecord@aol.com, courtofrecord@aol.com. Or you can call me, sir, 616-712-6179. Because, while for yourself being active duty, right, you have access to different courts than I do as a veteran out here that really can't, don't have access to anything. But you could go file charges, sir, and say it's a conspiracy. I'm just showing you that the conspiracy is the fact they didn't take the proper oath of office. Now, it's just not the president. The Congress, right? Nancy Pelosi, those people didn't take the proper oath of office. It goes all the way down to, through the state, the governor, the mayors, the judges. None of these people are taking the oath of office to satisfy the 6th Article of the Constitution. We should probably look at that real quick, so give me just a second. So here's the 6th Article, Debt Supremacy Oaths or Religious Test, where it says in the 3rd section, the senators and representatives before mentioned, that'd be Pelosi and Schumer and, take your pick, whoever you want to talk about, and the members of the several state legislatures. Okay, well, every state's got a legislature, so, and you got county legislatures that are in the state, yada, 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 and all executive and judicial officers, all executive and judicial officers, both of the United States and of the several states, shall be bound by oath or affirmation to support this Constitution. But no religious test shall ever be required as a qualification to any office of public trust under the United States. So that's what they ratified in the Constitution, sir. And then right afterwards, Congress got busy writing laws, and the very first law they wrote, right now that they had an outline of what they were going to build the government around, they started to pass the laws. The very first law passed is an act to regulate the time and manner of administering certain oaths, in which it says that the oath or affirmation required by the 6th Article of the Constitution of the United States shall be administered in the following form, to wit: I state your name, do solemnly swear or affirm, as the case may be, I will support the Constitution of the United States, period. That's the oath that satisfies the 6th Article of the Constitution. For the senators, right, where's our list again? Let's go look real quick. Senators and representatives, members of several state legislatures, all executive and judicial officers, both the United States and the several states, shall be bound by oath or affirmation to support the Constitution. But no religious test shall be required as a qualification to any office of public trust under the United States. Well, that's been violated, sir. It's really simple. But getting somebody to do something about it is the problem, because the Esquire is sitting as the judge, and he's sitting there as the prosecutor. Right? So when you go to court, that's where the conspiracy is. And so I'm going to show you, sir, that all of these patriots that are being held now, the 635 or whatever they are, being held by, in the District of Columbia, right, that when you look at the paperwork that's being filed by the prosecutors that the magistrate judges are allegedly using as the basis to write a warrant, well, nothing has been sworn to, right? It's all hearsay. There's a problem with that, sir, right? That's called conspiracy. So hang on. So, sir, under the UCMJ, then, the punitive articles, that's where we have conspiracy, and then soon after we have fraudulent enlistment, appointment, or separation. Well, that's what happened with Biden. He is fraudulently appointed commander-in-chief because he did not qualify for the office of the President of the United States, which is, the Commander-in-Chief is ex officio with being the President of the United States. Well, he's not, so he can't be the Commander-in-Chief. It's a fraudulent appointment. And I'm saying that you can file charges under the UCMJ, right, for a court-martial. Now, that's one way to do it. The other way is, well, you could go under Title 18, which is what I'm going to spend the rest of this video talking about, and is how I'm planning to try to do something about it. I'm not just telling you to do this, sir. I think every veteran or military member or anybody who gives a shit should look at what I'm saying here and try to figure out how to use it. So, and I just want to make sure that I have pointed out why the John Glover Roberts Jr., I believe he's a junior, and everybody else who sits in this room, which is supposed to be the Supreme Court of the United States, is under the Uniform Code of Military Justice. And it's the simple fact that we got these big-ass gold fringe flags flying here. Well, that flag only can fly where the military is, sir. It's in Army regulation, right? If you've not read it before, or, I don't know if the Marines have one like this. I guess I should go look and find out, right? But the Army certainly has one. It's called the Army Regulation 840-10, flags, guidons, on and on and on. Where it says in here, just real quick here, sir, give me just a second. All right, unauthorized use of official flags and so forth, that there is no law that permits the sale, loan, donation of flags, guidons, or streamers to individuals, organizations not in the military, except under military service, except as indicated in 1 and 2. Display or use of flags, yada, 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 including those presently or formerly carried by U.S. Army units and other office, individual, organization, which is authorized, is prohibited, except as indicated in 3. So basically, schools can have a flag, okay? Educational institutions. Retired generals can have a flag, right? And then for these particular reasons, these people can have a flag. But, that includes all these different flags, and one of them is the national flag. And if you go to Chapter 2, just real quick, where it talks about all these different sizes and so forth, Chapter 2, Section 3, where you have Section 3, sizes and occasions, you will see that the national flag listed below are for indoor display and for use in ceremonies and parades. For these purposes, the flag of the United States will be rayon, banner cloth, heavyweight nylon, trimmed on 3 sides with gold and yellow fringe 2 1/2 inches wide. And it goes on to say where it can be displayed. Authorization for indoor display. The flag of the United States is authorized for indoor display for each. And you can see what these are, sir. And there's one for military courtrooms, but it doesn't say anything about a civilian courtroom or Supreme Court or, a constitutional court or any of these things. It's because you can't have it there. If there's a flag, it's a military courtroom, period. Whether it has gold fringe or not, if it has a flag in the United States there, it's a military flag, or it can only be flown where the military has some jurisdiction, according to unauthorized use of official flags. I'm not arguing with it. I'm trying to use it to my best interest, so there you go. And just as an example to show you that it's just not Biden, right, that has this defect, this is back in 2019, I wrote to request the oaths subscribed by Gretchen Whitmer for the office of Governor of the United States, of the state of Michigan, and as Commander-in-Chief. Right? And so then I got an answer from the state of Michigan, which it's really not the proper entity, but so be it. Right? It's not state of Michigan. It's either Michigan or the state of Michigan. But they sent me what they had, which was this one copy here, which, before I marked it all up, you could look at it and say, well, that's the oath that satisfies the Michigan Constitution. But on closer inspection, you would find out, well, no, it doesn't really do that at all, because the style of the oath of the Constitution of the state is changed from what it is in the Constitution of Michigan, which has lowercase Constitution of the states, thus changing the meaning of the statement. Right here it is, Constitution of the state. When you look at it in the Constitution, it's all lowercase. Right? They changed the grammatical meaning of the sentence by the way that they changed the capitalization of the phrase. Right? And then Gretchen Esther Whitmer, which is her full legal name, right? That's the name on her driver's license or birth record or whatever you want to call it, right? Well, she put Gretchen Whitmer. Well, she's concealing her identity, right? You have to. This is supposed to be a legal document. You have to use your full legal name. But it only gets worse, right? She apparently had this administered by a notary public, and a notary is unqualified to administer an oath of office to the government, to the governor. See Michigan Compiled Law, MCL 1536 and MCL 1537. Right? So this isn't the oath that satisfies the Constitution of Michigan. It's a counterfeit. And under the requirements of 1 USC or 1 Stat 23 and the 6th article, all executive officers of the Michigan had to have taken this oath. Well, at some point, when they started writing the U.S. Code, they actually plucked it out of the 1 Stat 23 for how it affects state officers and made their own little section for it in Title IV of the United States Code, where it says in Section 101 that every member of the state legislature and every executive and judicial officer of a state shall, before he proceeds to execute the duties of his office, take an oath in the following form, to wit, I state your name, do solemnly swear to support the Constitution of the United States. Well, that said before, sir, before they could do anything, they have to take it. And nobody's taking this oath, so they're not qualified for the office. And that's the governor, it's the state attorney general, it's the state secretary of state, it's the state treasurer, it's all the judges, the justices of the peace, magistrates, whatever you want to call them. They're not taking this oath. They don't have any authority. And that's what's the problem with the United States. We've been denied a Republican reform of government because none of the people that are supposed to take the proper oath are. And most of those people now, like Whitmer, right? She's an attorney. She's an Esquire. She has no excuse for not having done this right. Right? She should be arrested immediately for conspiring against the United States. So that's the world that we live in. One little tidbit before we move on to Title 18 and the things that are happening in D.C. with this January 6th fiasco. Right? In Title 1, right, General Provisions, United States Code, Section 112, where it talks about the statutes at large, it says the United States statutes at large shall be legal evidence of laws, concurrent resolutions, treaties, international agreements, and other than treaties, proclamations by the President, proposed ratified amendments to the Constitution of the United States therein contained. And all courts of the United States, the several states, territories, insular possessions of the United States, they have to accept 1 Stat 23 as the law. Where it says, right, that the oath or affirmation required by the 6th article of the Constitution of the United States shall be administered in the following form. No other oath satisfies this. Now, they're taking other oaths, sir, but they're not taking this oath. And this is the only one that matters. This has never been rescinded. It's in the fucking statutes at large still. So it's the law. And it's the first law. And you can understand, sir, if we're not going to enforce the first law of the country, well, why would anybody follow any of the laws? So we need to go back to the beginning and say, hey, you need to have done this. You didn't do it. You don't have any authority. If you're an Esquire and didn't do it, well, you're guilty of conspiracy. Okay, sir, if you're still watching, thank you very much. And I'm going to change gears a little bit now and go to look at how this affects people in the real world, right? The world run by the devil, which is where we find ourselves. And what we need to do is split the devil's house, right? And so here's an example. I'm going to show you using Owen Shroyer of InfoWars as our example about what they're doing with people's paperwork in these cases for January 6th. And it isn't just for the cases in January 6th. It's just those are the ones we're going to look at. Right? They do this in every court case. Right? This is what Esquires do. They're defrauding the United States. So let me give you an example. All right, for those who don't know, Owen Shroyer gave an update on legal situation and defense funding. So you almost have to smirk to say that the Esquire is going to send you into this lion's den and they want you to pay them to do it, right? Because he needs money for his Esquire, who's supposed to defend him. But his Esquire is really conspiring with these other Esquires against him, which is the same as conspiring against the United States because Owen's a citizen of the United States. And the judge didn't take proper oath of office, and neither did the prosecutor. It just goes on and on and on, right? But I just wanted to show you some of his paperwork, right, that Owen's being charged with. So this is kind of the original document where it's supposed to be a criminal complaint on an AO-91 criminal complaint form, right? This is an approved form of the United States courts. It's supposed to be, except where it says attested to by applicant, right? That's not on the form that was approved by the United States. Right? That form looks like this, where it has down here, sworn to before me and signed in my presence, which is what you need to do with the sworn statement, with a complaint. You have to swear to it. But that isn't what happened. So not only did this Zia M. Faruqi, who's impersonating a United States magistrate judge because he didn't take the oath. It's in 1 Stat 23, right? So he's not a United States judge or a magistrate judge. He's just impersonating one. But he allowed them to put in a piece of paper that had changed the form of this official form of the United States. Well, then on top of it, a statement of facts, right? Because that's what it says here. Well, continued on an attached sheet. So here's the attached sheet. And that guy put in a statement of facts, right? Some guy pretending to be a special agent of the Federal Bureau of Investigation, because he didn't take the oath to satisfy 6th Article of the Constitution. So he's really not a special agent of the Federal Bureau of Investigations. He's just an impersonator. But he said he was the affiant. Well, that would mean that this is an affidavit, right? That's what affiants are. They're the person doing an affidavit. But this isn't an affidavit. It's not a sworn statement of facts. It's just a statement of facts. And it goes on for pages and pages and pages of statements of facts, which are all facts. But the fact of the matter is that this guy isn't a federal agent, and this guy isn't a United States magistrate judge, and they're using simulated legal process under color of law to deny Owen of his civil rights and liberties, and they're getting away with it. Right? This isn't an affidavit. There's nothing down here where he swore to anything. So Owen is being arrested under a criminal complaint that doesn't satisfy the federal rules of criminal procedure. Go figure. Right? Well, then they took that, and that was done in D.C., and they said, well, Owen's down in Texas. We got to send it down there, and they sent it down to Texas, and Texas gave it its own case number, right? Western District of Texas, that's what this is supposed to be. So now it has this new case number, apparently. And I think they added on this one the arrest warrant, which wasn't on the other one. Let's see, you got an arrest warrant for which is really a John Doe, right? This isn't Owen Shroyer's name, right? I mean, if it was just, they should know who it is they're trying to arrest. They didn't give him a date of birth, and they gave him an AKA. And so this isn't any one particular person. It's just a John Doe, right? And they want Owen to agree to be the John Doe. Come on in, be the John Doe, right? You agree to be this person here so we can do what we want to do to you. You're being led down the path by his Esquire. So anyways, United States, you see how this form is set up, right? Where it has United States District Court for the District of Columbia. Now, apparently that's okay because that's the way the original form is. So, right, that's the way that we should find the courts being identified by on these other documents. But it's not the case. See, on this next document, which is supposed to be the government's notice of attorney appearance, which they have a form for, by the way, right? But they're not using it. They said the United States District Court, Western District of Texas. Well, that isn't what it said. It should be United States District Court for the Western District of Texas because that's where the damn complaint went into. Right? U.S. District Court, Western District of Texas. But they're using the for the paperwork. Right? And they gave it a case number. But when we go here and look at this, well, it has that case number up here, but it's not the case number they're using down here. So this court here with this number is not the same as the for the court with this number. That's the way they did it. Now here's another form, AO 467. Let's go see what that is. So here's an AO 467 form. It says United States District Court for the. But when we look at what they put in for Owen, it says United States District Court and doesn't have any for the. They changed the frickin' form. And it doesn't say United States of America, it just says USA. Right? They intentionally changed the form. Right? United States of America versus the defendant. United States District Court for the. Put the information in, right? Fill the blanks in. But that isn't what they did. They acted like they're doing that. And then they gave it a different case number. What's this? AU21M? That has nothing to do with this number at the top, which is the number they're saying is the court case number for Owen. Right? Here's one that says for the. Right? Here's United States District Court for the Western District of Michigan, or of Texas. With 121, but no MJ06. So even this court case number isn't the same as this court case number. And this says it was filed in this U.S. District Court, Western District of Texas. But here it says the United States District Court for the Western District of Texas. You can see the inconsistency, sir. This is being done by Esquires. Intentionally. All right, here's another one. United States District Court, Western District of Texas. So there's no for the. It's USA, not United States of America. And it's got a different case number than as at the top of the document or on, the other documents that they're using against Owen. He's going into some case, AU21M, right, believing that's the case he's going to, but they're putting the records over in this file over here. Right? This isn't, I don't know what to say, sir. It's just very frustrating to have known these things all this time. I really can't do anything about it. I don't know what the answer is, except to show other people. So that's what I'm doing again. Here's United States District Court, not any for the, with the AU number, right? Saying that the charging district case number is 121MJ527 or 572, which it really isn't. It's close, but it's not exactly the same. And this is supposed to be the notice of appearance of counsel, right? Which isn't the form to use. They have a form for that, but they made this one up, and some dude with a middle initial who says he's admitted to WD Texas, right, is going to be his attorney. And this is the guy that Owen's online shilling money for, so this fucker can supposedly defend him. And Owen's going to be led down the path. Here's another one, right, where they took the AO form and they changed the title. 466. AO 466A, United States District Court for the. Put in the name of the court, United States of America. Okay, well, what'd they do with Owen? No, we're not going to do that. We're going to get rid of the for the and put our own title in and get rid of United States of America and put in USA. Right? USA without any initials, that's United States Army. So now they're saying the United States Army is versus Jonathan Owen Shroyer. Well, some Esquires got some shit to answer for, sir. So that's, just an idea of what they do. Every case may be a little different, but they all have these errors in them. I've been pointing it out for some time in a number of videos for quite some time. But what are you going to do about it? Right? So, well, recently I was reading Title 18, so that's what I'm headed to next, right? This is what I'm going to try to do about it. So hang on a second. So the question begs to be answered, sir, why aren't the attorneys that are appointed as for defense counsel for the people that have been criminally charged bringing up the fact that the criminal complaint and the statement of facts and so forth are legally insufficient? Instead of having the guy go answer for the freaking charges, say, well, when you get the charges legally sufficient, then he'll have to answer. But until then, you're just simulating a legal process under color of law, because that's all this is. Once you change this form, it's no longer what it was agreed to be. I mean, the United States court said this is the form. They altered it. They made counterfeits. They're conspiring against the United States. It's really that simple. And then in every defendant's case, Owen's a little bit different, right? They actually in D.C. have him under 3 different names. They got Shroyer Jonathan with an A and Shroyer Jonathan with an O, and then just Shroyer Owen. But in each case, with an A has 2 court cases against him, and with an O has 2 court cases against him. Now, they're the same court cases, but there's 4 court cases between these 2 different names. Well, that's like being charged twice for the same crime, because they're all for the same reason. Excuse me. And that doesn't even include the ones that they opened up down in Texas now. It's on and on and on, right? So we got to figure out what to do about this shit, because this is a conspiracy against the United States. And that's where I'm headed to now. What am I going to try to do about it? Okay, so in Title 18 of the United States Code, which is Crimes and Criminal Procedures, it has this section, Section 3041, Power of Courts and Magistrates, within which it says that for any offense against the United States, let's just stop there first, right? So if you want to use the right words, you need to call it an offense against the United States, right? So for any offense against the United States, not crime, not conspiracy, yet, right? For any offense against the United States, the offender may, by any justice or judge of the United States, or by any United States magistrate judge, or by any chancellor, judge of a supreme or superior court, chief or first judge of a common pleas, mayor of a city, keep that one in mind, the mayor of the city can do this, justice of the peace or other magistrate, which, who can that be, of any state wherein the offender may be found, and at the expense of the United States, be arrested and imprisoned or released as provided in Chapter 207 of this title, as the case may be, for trial before such court of the United States as by law has cognizance of the offense. Copies of the process shall be returned as speedily as may be into the office of the clerk of such court, together with recognizance of the witnesses for their appearance to testify in the case. A United States state judge or magistrate judge shall proceed under this section in according to the rules proclamated by the Supreme Court of the United States. Any state judge or magistrate judge hereunder may proceed according to the usual mode of procedures of his state, but his acts and orders shall have no effect beyond determining, pursuant to the provisions of 3142 of this title, whether to detain or conditionally release the prisoner prior to trial or to discharge him from arrest. That's a lot of words there to say, well, I should be able to file a complaint for an offense against the United States with anyone, including the mayor of the city, right, who should be able then to arrest the person that's committing the offense against the United States. So it really comes down to, well, what's an offense against the United States? Right? And as it turns out, well, you can download a complete copy of Title 18 if you want to. So I did. And I put in, well, offense against the United States, and said, well, there's 26 different hits in here. Let's just take a look, see what they are. All right, so in Section 2, whoever commits an offense against the United States or aids or abets counsel's command, so forth and so on, is punishable as the principal. So you don't call him a defendant or criminal, you call him a principal. Right, I get it. So the principals are the ones who offend, who commit offenses against the United States. Right, and there it is again, accessories after the fact. Whoever, knowing that an offense against the United States has been committed, receives, relieves, comforts, or assists the offender in order to hinder or prevent his apprehension, trial, or punishment is an accessory after the fact. Well, I'm saying that's what these Esquires are. They're the principals in an offense against the United States because they're altering forms and, doing all sorts of things. Conspiracy to commit offense or to defraud the United States. If two or more persons conspire, either to commit any offense against the United States or to defraud the United States, or an agency, therefore, in any manner or for any purpose, and one or more of such persons do any act to affect the object of the conspiracy, each shall be fined under this title or imprisoned not more than 5 years or both. That's what I'm saying that the Esquires are doing. Incarcerated person, destruction, misuse of vessel, special assessment. I just want to get down to this one part where they eventually show who has the authority to do something about it. Let's see here. So, all right, powers of Federal Bureau of Investigation. Agents of the Federal Bureau of Investigation, not special agents, just agents, right? This is the thing. It didn't say special agents. It says agents of the Federal Bureau of Investigation of the Department of Justice. They may carry firearms, serve warrants, subpoenas issued under the authority of the United States, and may make arrests without warrant for offenses against the United States committed in their presence. Well, if they would just watch what Biden and Glover did, Justice Roberts, John Glover Roberts, Jr., they would say, well, there's the conspiracy. They could go ahead and arrest him without a warrant. Marshals, right, cannot make any offense against the United States committed in their presence. Right? Conspiracy is an offense against the United States. So if it's being done in their presence, they could do it. United States Secret Service, well, they can do it. Make arrests without warrant for any offense against the United States committed in their presence. You can't tell me you guys weren't around when this stuff was happening in the happening on Inauguration Day. And then there was somebody else, ATF, I think, also has it. Right, that's Secret Service. United States Secret Service, Marshals. Yeah, here we go. Powers of special agents of the Bureau of Alcohol, Tobacco, and Firearms, right? So now it's special agents that have the authority. Under the FBI, it's just agents, not special agents. And you would see it was a special agent that was filing the complaints against all the people involved in the January 6th fiasco there in D.C. Right? But so my point is there's these entities in the government that don't need a warrant to effect an arrest. Right? If it happened in their presence. And to me, we'll show them a copy of the frickin' the paperwork and say, well, now it's in your presence. Right? So that's one of the things I'm going to try. I'm going to try sending something to the special agents of the Bureau of Alcohol, Tobacco, Firearms, and Explosives, and also to the Secret Service, which I think it's the uniform services you got to send it to. But more on that later. Anyways, I'm just, you know. But the thing is, this thing about the conspiracy, that it's considered an offense against the United States. Now, I want to look a little bit deeper at that, because that's where the rubber will meet the road. Give me just... okay, here's that same section, 3041. I like to put them on paper and color them sometimes, and I had done that, so I just want to run through it again real quick, right? So powers of courts and magistrates for any offense against the United States. That's what we're trying to get. It's not an offense against you or me. It's an offense against the United States, which we may be a victim of, right? But it's an offense against the sovereign, the United States. So it goes to a different level of court. This is the point. It's not individual against individual. It's now conspiracy against the sovereign. And if we would have been in England still, we'd say the king, right? And so it would go to the king's court. It wouldn't go to the lower courts. And the people that can take it is somebody like a mayor of the city, justice of the peace, or other magistrates. So who are the other magistrates? Right? Well, one of the things that a mayor can do is a mayor can solemnize a marriage. Well, so can a preacher. And I've said before in these many videos, right, that preachers have access to gold fringe flags. Right? They're in their frickin' office. It's like you're a member of the military because you have a gold fringe flag. And it was given to them in 1917 when they had these churches create these civil organizations that they gave military commissions to under the wartime powers during 1917, and they haven't gone away yet, and they still had the flag. Right? So I say they could do it. Right? This is where I talk about having somebody do the sworn statement for them. Let me show that real quick. So if you went back and watched a few of my older videos, if you haven't seen these before, you'd see I did one on Christian Church's wartime pledge to God, country, and flag, which all this happened in 1917. Right? It's all in there. And then denominationals commissioned to serve God and country, or God and country, right? Just to follow up on it, that these churches got gold fringe flags, and that flag, as I showed before, it's only can be where there's a military presence. And the reason there's a military presence in the church is because of the commission that the churches were given by the Department of War in 1917. Had nothing to do with Congress. And they still have it. And so I'm saying that I should be able to take them a sworn statement form. This is the Army version. Just going to use it as an example of what a sworn statement looks like, where it has the information with you saying you want to make your sworn statement. And I want to, in my sworn statement, say that, X, Y, and Z have conspired against the United States to defraud the United States. And then go on to explain what it's about. And when you get done with your explanation, you get to the last page, and there's where the affidavit is, right? There's an affidavit in a sworn statement, but the sworn statement is not an affidavit, right? It's just done under an affidavit, where you're going to say that you've read whatever is above, and you agree that that's your statement. Now, a military officer doesn't understand what this form is. And then you get to this part over here, subscribe sworn before me, right? Well, who can do this? Signature of person administering oath. Authority to administer oaths. Right? Now, a commander, a company commander could do this, right? He would have the authority to do it. But I'm saying a church could do it because they have a gold fringe flag. So I should be able to have the preacher put his name down there. And, what's his authority to administer the oath? Well, he's the rector or priest or pastor or whatever of whatever the proper name of the church is. And that's all that it would take. And then that the military would accept that as proper oath. Now, I don't know that that's who these other magistrates are they're talking about. Let's get back to that, right? Because who are the other magistrates? Right? Well, if a mayor of the city could do it, then my township supervisor should be able to do it. Because he's supposed to be able to take a sworn statement. That's all that we're talking about, is take a sworn statement that somebody committed an offense against the United States. Right? So the United States is the victim, and you're the relator, because you're the one bringing it to their attention that this has happened. But once that has happened, and the copy of the process, well, what's the process? Well, that's the sworn statement. Right? It should be returned to the office of the clerk of the court, of such court, together with recognizance of the witnesses for their appearance to testify in the case. And this is the part that I have to get figured out is, well, what do we need to give a recognizance? Do I need to give a recognizance bond? I'm happy to do it. Right? Whatever they need to be satisfied for my recognizance. But once that's been filed into the clerk of the court of the district court, and here's the Western District of Michigan, and it's been done in that fashion, then the judge has to follow the frickin' rules that are in the rules of criminal procedure because they were promulgated by the Supreme Court of the United States. Okay, so, and just because I had seen this, one other thing was, if you go to 18 U.S.C. 23, right, just 2318 United States Code, Section 43, Court of the United States defined, it says, as used in this title, it'd be Title 18, except or otherwise expressly provided, the term Court of the United States includes the District Court of Guam, the District Court of the Northern Mariana Islands, and the District Court of the Virgin Islands. Well, I didn't say anything about the District Court of Michigan, right? The United States District Court for the Western District of Michigan. That's not listed in there. It just lists these three courts as being courts of the United States. I think that's very interesting. However, it doesn't mean that the judges, right now, because, we're not talking magistrates necessarily, magistrate judges. We're talking about the judges, the United States judge or magistrate judge shall proceed under this section according to the rules promulgated by the Supreme Court of the United States. They have to do that when you have done this first section properly. Right? So we need to take it to the mayor or their magistrate, whatever it is, to get them to take our sworn statements as provided in Chapter 207 of this title. Right? Arrested or imprisoned or released as provided in Chapter 207. So Title 18 United States Code, Chapter 207, which in that particular chapter of Title 18 is release and detention pending judicial proceedings. Right? Yada, yada, yada. So as long as they're following these sets of rules, where did I put it here? Hang on a second. All right, so for me, the question is, well, who do I go see that fits this first paragraph, right? Now, if you've been following me for any time, you know that I went back in a year or so ago, and I filed a complaint against Whitmer for not having a proper oath of office, right? And I sent it to the 63rd District Court, which is, that's supposed to be my local court. So is this judge or this judge, is that who they're talking about? Are they the ones that could do it? Because what I did at the time, right, is well, that isn't it. Hang on here. All right, so what I had tried to do is I said, well, I'm going to take the state form that they use for complaint for a felony, right, which is people of the state of Michigan versus, and I put Gretchen Esther Whitmer, right? The complaint was the United States. I was the complaining witness. Yada, yada, yada. What am I complaining about? Well, basically the fact that she didn't take proper oath of office. All right, so that was I was complaining about. Well, a couple weeks later, I get this in the mail, right? Notice of hearing, where they gave it this case number. They didn't put what court it was or any of that kind of stuff. They just gave it a case number. My name as the plaintiff, right? Whitmer, Gretchen Esther. Not the way that I put it. That's the way they did it. But it said that there would be a hearing on Thursday, the 9/17/2020, in person, in which the defendant had to come and answer. The defendant is required to attend this hearing. It didn't say I did. The plaintiff isn't required. It said the defendant. Right? So, well, on the same day, I get this other one that says it's amended. And on this one, it says that the plaintiff has to attend. And they changed some of the other wording in there, right? But, but I'm looking at it and say, well, if you're saying this one's amended, then that means this other one is the one that's in force. Right? This doesn't have on there that it was amended. So this one must be fine. It was this one that was amended. The one saying that I had to show up. Right? So, anyways, I had tried it before, but what I was doing then was I was using the state form, and I wasn't saying that it was a complaint against the United States, an offense against the United States, which is what I'm going to try to do this time. So I may end up sending it to the same people again. But, I don't have a mayor of the city. I don't live in a city. I do have a township supervisor, so I may send it to him. See, in a case like this, if you're trying to point out, like in Owen Shroyer's case, or anybody that finds himself as a defendant in a court case, especially a criminal case, right, that the person acting as the prosecutor and the person acting as the judge are conspiring against the person they claim is the defendant because nobody has sworn to the complaint. Right? So, and the people that have taken you, that have you in court, didn't take a proper oath of office. So now taking a proper oath of office, well, that isn't necessarily a conspiracy if you're doing it by yourself. But what it is, you could say it's defrauding the United States because it's a contract, deed, or power of attorney. Right? It's whoever utters or publishes as true any such false, forged, altered, or counterfeited writing with intent to defraud the United States, knowing the saying to be false, altered, forged, or counterfeited, yada, yada, yada. Right? So this is the thing about being defraud the United States. And that's what I wanted to show next in this thing about conspiracy. That, find that page 2 real quick. Right, this comes out of the United States Department of Justice Archives. And I think this has been like the Criminal Resource Manual. We'll go figure. Look at that. Home Justice Manual, Criminal Resource Manual, da-da-da-da. Section 923, in which it says that the general conspiracy statute, which is 18 U.S.C. 371, creates an offense if two or more persons conspire to either commit an offense against the United States. Remember, that's a thing that this other section talks about. It has to be an offense against the United States, or to defraud the United States, or any agency thereof in a manner or for any purpose. The operative language is the so-called defraud clause that prohibits conspiracies to defraud the United States. This clause creates a separate offense from the offense clause, right? So it makes it an offense against the United States to conspire. Both offenses require the traditional elements of 371 conspiracy, although this language is very broad. Cases rely heavily on the definition of fraud provided by the Supreme Court in 2 earlier cases. So what is the definition of defraud? Right? Include any conspiracy for the purpose of impairing, obstructing, or defeating the lawful function of any department of government. Well, that's what the frickin' prosecutor and the guy acting as the magistrate judge are doing. Right? They're conspiring to obstruct the lawful function of a department of government. Would be operation of reports as fair, impartial, reasonable, accurate would be to defraud the United States by depriving it of its lawful right and duty to promulgating and diffusing information so officially required, yada, yada, yada. So in this case, Chief Justice Taft, who had been the president and then became a Chief Justice afterwards, to conspire to defraud the United States means primarily to cheat the government out of property or money, but it also means to interfere with or obstruct one of its lawful government functions by deceit, craft, trickery, or at least by means that are dishonest. Well, if you're sending people to jail based on unsworn complaints, that would be dishonest. It is not necessary the government shall be subject to property or pecuniary loss by the fraud, only that the legitimate official action or purpose shall be defeated by misrepresentation, chicane, or overreaching of those charged with carrying out the government governmental intentions. And so, as I've shown numerous times, you can go and look to see when Congress is seated for the first time. That's when they're supposed to everybody take their oath. And they're supposed to take the oath to satisfy the Sixth Article of the Constitution. But that's not the oath they take, and they don't do it on the first day properly, and so forth and so on. I pointed all that out again in this video here with the general, right? That you can download the congressional record and go find what they did and see what they did, and see that they did it wrong, and that when they did it wrong, they did not use their full legal name, and they did it all as a group. Well, that would be a conspiracy, right? The guy giving the oath didn't give the proper oath to the people taking the oath, and they accepted that as proper, and they went ahead and do it. Well, that's a conspiracy. Whether they know it or not, it defrauded the United States. They're guilty of a conspiracy. Now, we can show mercy if they didn't know what they're doing, but I'm saying if you're learning the law as an attorney, you don't have an excuse. You're guilty. Any conspiracy for the purpose of impairing, obstructing, or defeating the lawful functions of the Department of Government. Well, that's what they did. That's what Esquires had done to the courts. The defraud part of 371 criminalizes any willful impairment of a legitimate function of government, whether or not improper acts or objectives are criminal under another statute. Right? You didn't take the proper oath of office. There's not a statute that says that's wrong. But the fact that you did it and that's going to impair the government, well, that makes it wrong. The word defraud in Section 371 not only reaches financial or property loss through the use of a scheme or artifice to defraud, but also designed and intended to protect the integrity of the United States and its agencies, programs, and policies. That's the part I'm talking about. Thus, proof that the United States has been defrauded under this statute does not require any showing of a monetary or proprietary loss. Just show that they did it wrong, that they filed a complaint that hasn't been sworn to, and you got an attorney that's trying to charge you with that before another Esquire that's sitting there in judgment. And none of them are saying, well, this isn't a proper sworn statement, which is the first step that's required by the Federal Rules of Criminal Procedure. So the thing is that once you say it's an offense against the United States, well, then they have to file the Federal Rules of Criminal Procedure, because they were written by the Supreme Court for the court to follow. Right? And that was all covered in here where it says the United States magistrate judge shall proceed under this section according to rules promulgated by the Supreme Court of the United States. Well, those rules would be called the Federal Rules of Criminal Procedure. So none of that shit's happening right now. That's just the way it is. And so, without getting into this anymore, I mean, it goes on and on and on about these different things, right? That there's three ways to commit a conspiracy against the government, right? To cheat the government out of money or property, to interfere or obstruct legitimate government activity, or make wrongful use of government instrumentality. Well, that's what they're doing with the courts. So that's what's going on, right? And it's covered by Title 18. And the simplest way to look at it is go to Section 3041 and read the first paragraph. Say, well, okay, you need to file a piece of paper that satisfies this section here and make it an offense against the United States. And, call it that in the paperwork and see what they do with it. And remember that people that commit an offense against the United States are called principals. Right? That's in Section 2 of Title 18. As far as the colonel himself, well, he gets to use the UCMJ. So he could file it under the UCMJ that Biden and Roberts conspired against the United States by giving Biden a wrong oath of office. And because they're both lawyers, attorneys, esquires, well, they don't have an excuse, right? They're guilty. So that's my story. I'm sticking to it. and I'm Staff Sergeant Robert Allen Retluski, Army of the United States, a.k.a. Rob Ryder. Emails courtofrecord@aol.com or phone number 616-712-6179. But I'm hoping that somebody other than myself and the colonel here put some paperwork in, right, and test the system to see what happens. All right, because this is the conspiracy, and they may defraud the United States an offense under this section. So let's try to find a use for it. Okay, I'll have more later. Y'all have a good day. See ya.